They come to an end by discharge of performance, and we discussed those 4 different aspects of performance. We discussed that they can come to an end by mutual agreement. Both parties can agree to walk away. They can come to an end by involuntary discharge. 1, because it's impossible to perform. Maybe the subject matter of the contract got destroyed, or the law changed. Then that would be basically an involuntary discharge. And then lastly, we discussed how a contract can come to an end because one or both of the parties breached the contract, meaning they failed to perform as they're supposed to perform in the contract. Other ways that we can have contracts come to an end are via transfer of the contractual rights. You can sit right there. Thank you. Transfer contractual rights or duties. If we transfer of rights is called an assignment of rights. And when we transfer rights under a contract to another party, generally speaking, it has to be communicated what is being transferred. You can't just, transfer an obligation to somebody without that other party being willing to accept that obligation, or the other party being willing to accept the benefits of that contract. Typically speaking, when we're talking about an assignment of rights, we're talking about an assignment of what you're going to benefit in a contract. So if, for instance, I had a contract with Ben, and Ben was going to build a deck at my house. And I was going to pay Ben $5,000 in exchange for him building that deck. Ben has a contract with me. We've got our benefits and our detriments. My benefit is I'm going to get a deck. His benefit is he's going to get $5,000. Ben can choose to transfer his benefit in the contract to another person or another party. He can decide that he wants to give that money to Aiden. Maybe he owes Aiden $5,000. So he decides he's going to transfer his right to receive the $5,000 from me. He's going to transfer it directly to Aiden. He can do that. That's his right. He can transfer his benefit to another party. If he's going to do that, he has to communicate that not only to Aiden, but he has to communicate that to me as well, so that I know how I'm going to direct my payment in that contract. So instead of directing my payment in the contract to Ben, I'm going to direct my payment to Aiden. Okay? However, as it relates to his obligation, he's got an obligation to build the deck. That's called a delegation of duties in the contract. If he wants to delegate his duties or do what's called a novation, okay, transferring of his duties, he's got to receive approval from me to be able to transfer that duty to Aiden. I might be fine with contracting with Ben for him building the deck, but I obviously don't know anything about Aiden and his ability to build a deck. So I may not be comfortable with having Aiden build my deck. Okay? So as it relates to duties or obligations, you have to make sure you get the approval of the other party before you can transfer or delegate your duty. Okay? Defective agreements. One type of defective agreement is fraud. And fraud consists of a false representation of a fact. You must know, the fraudulent party must know that whatever they're stating is a lie. God bless you. They must intend the lie to be relied upon, and then the lie has to be relied upon, and there has to be a loss in order for there to be fraud. So those elements, let's see if the pen writes today, here's the mystery. Not writing good. Okay? So those four things, if you will, write that down. Those four things are all elements associated with fraud. In order to have fraud, you have to have a false representation of a fact, know that you're making a false statement, the false statement has to be relied upon, and there has to be a loss. Fraud is different than what we call innocent misrepresentation. If the party didn't know that they were making a false statement or misrepresenting, the contract can still be gotten out of, but it's a determinant as to whether it's a fraudulent statement or an innocent misrepresentation as to whether or not there can be any penalties associated with the defective agreement.
What would be like an innocent representation?
Okay, innocent misrepresentation. Yep. Okay. So let's say I'm selling a house, and down in my basement, I have a crack in the foundation. Somebody comes in, they're looking at my house, and they're interested in buying it. And they're like, "Oh, I wouldn't buy that house. It's got a crack in the foundation. You're going to have leakage and so on and so forth." So after a few people say this, I decide I'm going to build a wall in front of this crack in my build a wall in front of this crack so that nobody knows there's a crack in the foundation. And then when people come to see my house and they ask me, "Are there any problems with the foundation?" I say, "No, no problems. It's all good." And then, they go forward, they buy the house. 6 months later, they're in the house, and all of a sudden the basement floods. And then, lo and behold, they have a contractor come in and they tear back the wall, and they see that there's a crack in the foundation. That would be fraud. I basically made a false statement of facts. I knew it was a lie. I intended that lie to be relied upon. They relied upon my statements, and then they had a loss. They ended up having to have, the basement repaired. Separate from, I build a wall in my basement, years go by, I have a wall up there, somebody comes in to buy my house, everything's good to go, and after the fact, they ask me, "Are there any problems?" And I've never had a problem. And then after the fact, they buy the house, and then they tear down the wall, and there is a crack, but I never knew about that. I never had any problems. There was no evidence of problems or flooding in my basement prior to that.
Can you just say that, though, for the fraud? Can you just say you didn't know?
You could, but if they determine that you lied, then there's fraud. I mean, can you get away with fraud? Of course you can. Of course. There are people that do all the time. But if they can prove that you fraudulently misrepresented, then you can be held accountable and penalized. Yes, Aiden, you had a question first, and then Logan. Yeah.
So if it was there, but you didn't know about it.
That's innocent misrepresentation.
What if that, that you knew about, they think that you knew about it?
Well, I mean, you would probably have to go through an evidentiary process. If they were going to sue you for what you knew or what you didn't know, you would go through an evidentiary process. I mean, the fact of the matter is, if you've got a hole in or a crack in your foundation, and your foundation is leaking into your basement, you're going to know. And you're going to have problems in your basement with flooding and water, and there will be evidence of that in your basement. There'll be mold, there'll be different things.
What if you get it fixed and then it cracks again?
You could, I mean, if you don't represent that, then that could be considered part of the fraud. I mean, the fact of the matter is, if you know that there was an issue or is an issue, and you communicate that, and you let the people make their decision based on that knowledge, you're not committing either misrepresentation or fraud. You know what I'm saying?
Yeah.
Logan.
Never mind, that was my question.
Okay. All right. So, other defective agreements are contracts or agreements made under duress. And duress, just so you write a definition down, duress is basically when you're overcoming somebody's free will to make a decision. So if you pressure somebody into coming to a decision or contracting, that would be duress. If you threaten them with a gun or you threaten their family, that would be considered duress, and that would be a defective agreement. Contracts entered into under duress are not valid contracts. Then we have contracts where there's undue influence. Undue influence is slightly different than duress. Undue influence is basically when one person is in a position of trust and they influence you to enter into a contract in one fashion or another. So a position of trust might be somebody who's a family member and you're relying upon that family member to give you advice about what you should do. And if they're acting more in their own best interest than in your best interest, then that would be somebody who's exerting undue influence. Okay? And then we have contracts that are entered into that are mistakes. Two types of contracts that are mistakes, where we have, the first is a unilateral mistake, and basically a unilateral mistake won't end a contract. Typically a unilateral mistake is where one person only in the contract makes a mistake. They don't understand the nature of the agreement. So for instance, if I entered into a contract to say mow Ryan's yard, Mr. Levy's yard, and I thought his yard was, a certain amount of space, and I didn't understand that it was maybe more space, and I agreed to contract, it's a unilateral mistake. So I didn't understand the nature of the agreement, and so therefore I can't back out of that. If it's a bilateral mistake, the contract can be terminated, meaning both parties have a mistake as to what was contracted. Both parties have a mistake as to what the actual agreement is. Okay? Unilateral mistakes you're responsible for. Bilateral, both parties can agree to mutually terminate the contract. And even with unilateral mistakes, these are people, like even if somebody, sometimes unilateral mistakes, people enter into a contract, they didn't understand the terms of the contract, they didn't understand, maybe they didn't understand the payment structure, things like that. Those are unilateral mistakes. You are still bound by that contract. Even if you're like a foreigner and you don't speak the language very well and you enter into a contract, you can't get out of a contract because you don't speak the language fluently. Okay? All right. When contracts come to an end, what are our remedies and damages? A remedy is a legal means of enforcing a right or correcting a wrong as it relates to a contract. It's a way of compensating the injured party. And the injured party can decide to accept the breach and just walk away. They can decide to sue for damages, or they can request an equitable remedy. Does anybody remember what equitable remedies are? We've talked about that once before. In torts.
In terms of property.
Pardon me?
In terms of property or money.
That is comparable. Okay, so an equitable remedy, we talked about before, is typically when we're dealing with either an injunction or a requirement by the court to specifically perform. And so in either of those two situations, that's an equitable remedy. You're going to ask the court is going to ask you to basically do what you were requested to do under the contract. Damages, these are payments that would be recovered by the injured party. Typically, we think of them in either monetary or punitive remedies, damages rather, punitive or monetary damages, and we talked about those as well in the past. Basically, monetary damage is going to compensate you for whatever your loss is. Punitive is intending to punish the wrongdoer. And then again, here's our equitable remedies: is the specific performance or an injunction. Yes.
The contract, like a breach of contract ever, or a this contract or a bad contract, ever become like a valid
Well, if there was maybe fraud involved and it was a criminal situation where they committed some sort of fraud of a criminal nature, then it could be, if it was determined that there was some sort of crime committed. Yes, it could be. Okay. All right, let me just, 1 second, let me just see if I can turn my recording off.